SJC-12675, the McLean Hospital Corporation v. Town of Lincoln.
Ms. Tillotson, good morning.
Good morning. May it please the Court, Diane Tillotson and Pat Moore for the McLean Hospital Corporation. This court described the term education over 100 years ago as broad and comprehensive and directed to the mental, moral, and physical capabilities of its recipients. The issue before the court this morning is whether a structured, comprehensive, social and emotional skills development curriculum adapted for adolescent boys in an immersive residential setting, a curriculum that is indisputably educational, becomes something else when it is also curative or therapeutic, and whether there's any basis for the distinction created by the land court that outward-facing skills are educational while inward-facing skills are not.
I wanted to ask you about that, please, Ms. Tillotson. Has anybody ever used that dichotomy of outward assimilation, people skills, as opposed to inward treating mental illness in this context or even in another context?
Not that I'm aware of, Your Honor, and certainly no appellate court has made that distinction, nor has any trial court, and that includes the land court, the superior court, and the district courts, the few district court decisions that there are, have ever created that distinction. And I would suggest it was the land court's mechanism for getting to the result that it arrived at.
The parties had not arrived, the parties had not discussed this with her, had not argued it? The parties had not argued that?
The parties did not argue this distinction, Your Honor.
I don't know what the genesis of it is.
I do not, other than,
But
and
a course
it's,
in Buddhism would do.
I'm sorry,
A course in Buddhism would be pretty inward-facing, don't you think?
a course in Buddhism? Yes, although
Not
one
curative
could
or-
argue, I am not a master or a Buddhist, but one could argue that Buddhism presumably is the goal, one of the goals is to change outward behavior and the way people interact with each other. I don't know.
It's in the land court judge's decision on this inward-outward. It's part of her decision, but not the main part. But isn't it more takeoff on the life skills dichotomy that some of the cases have discussed?
Well,
versus-
I don't think there is a life skills dichotomy per se. I would suggest to the court that the skills taught by or in the McLean curriculum, namely mindfulness, interpersonal relations.
I meant life skills in the other cases. And we need to really put a point on what is being offered in the like. We'll get to that. But the other cases do talk about life skills.
They do, and I would suggest to the court that these skills, interpersonal relations, are every bit as necessary for succeeding in life as learning how to budget, personal hygiene, and those types of skills. There should be no dichotomy between interpersonal relationship and those types of social and emotional learning skills and the types of skills that are involved in maintaining or cooking a meal or budgeting or personal hygiene.
But
They
I
are
think
both necessary to succeed in life.
Along those lines, I think that the appellees are saying, well, sure, there's this general utility that exists, and we see these life skills in many education contexts, but that still is not the primary purpose. That the primary purpose here really is to treat mental illness, not to educate. And they obviously distinguish Fitchburg and Gardner and all those other cases as well in doing so. What are your thoughts about that?
Well, first of all, I don't think that Fitchburg can be distinguished from the facts in this case, and I would suggest that there may have been a confusion, or at least a confusion on the part of the defendants and the appellees, created by the Regis decision from this court several years ago. I would suggest that the Regis decision, in fact, reaffirms the principles in Fitchburg, and that Fitchburg suggests that life skills are educational, whether those life skills are directed to persons with mental and emotional health issues, or whether they're directed to the typical K through 12 learning.
I don't know how anyone could argue with that, that point. As I understand the appellee's position, though, is that here, the whole concept is to address mental illness, and that if you look at the whole arc of this, that it's really treatment, not education, and that every aspect of treatment, or almost every aspect of treatment, has, by definition, some element of education.
Well, the purpose in this case, Your Honor, is very clearly to teach the educational curriculum known as dialectical behavior therapy, very well-developed curriculum that has been adapted for this particular population. This is taught in a classroom, on a very structured schedule, by persons who are given very specific training in how to impart skills which the population which is served lack. And these are social and emotional skills. The program is directed, and the main purpose of the program, I would suggest, is to teach those social and emotional skills. That purpose is educational. It is also therapeutic, and it is also curative. And I would suggest to the court that the land court's error was in making a construct that it has to be either educational or curative or therapeutic, and not both.
Is there a primary purpose test as well?
I think that primary or dominant, those words were used in the Regis decision by this court, by Justice Lenk, as a matter of fact, and I think the primary purpose, excuse me, Your Honor,
Just like remembers.
I think the primary purpose is clearly to teach this particular curriculum.
Do you agree that there can be primary and secondary purposes?
There can be primary and secondary purposes, yes. But I think in order to determine whether or not Dover protects the particular use, the particular program in question, one needs to look beyond the nomenclature and the terms and look at the actual program that is being, that essentially is the use of the land in question. And that was the question in Regis, whether or not the program there was really educational, or whether it was essentially a luxury residential complex in Weston.
Can I ask a clarifying question?
Certainly.
So, in this case, the parties agree on the facts, right? Everybody agrees on the components of the program and all of that. Isn't that right?
That's correct, Your Honor.
And in the findings that the land court judge made are based on the agreed-upon facts.
That's correct also.
We're really looking at this de novo? I mean,
This is a de novo question of law for this court. And again, McLean does not dispute the facts found by the land court. McLean disputes the application of the law to those facts.
You think it makes a difference that it's a residential program? I mean, 3 East for girls is not a residential program. It's just a DBT curriculum.
Actually, I believe there is a residential 3 East program for girls. There is also essentially an outpatient.
A day program.
A day program, yes.
Yeah, which is just much more purely educational, wouldn't you think?
No, Your Honor, because I think this court's cases and case law essentially supports the notion that immersive residential programs are educational because not only are the classroom skills imparted on a daily basis, but the residents are then able to practice those skills not only in defined practice sessions, but also when they have meals together, when they're outdoors in recreational settings together, when they go on field trips together.
Those are all teaching moments.
They're all opportunities to practice the skills that are at the core of this program.
Or they're teaching skills.
They are, Your Honor. They're teaching moments, as you would
Moments,
say.
yeah.
Isn't Regis different here? I remember it too. She wrote it, but I remember it. In Regis, as I recall it, there was no dispute that what Regis was offering for its residents was educational. The question was whether or not the educational element was its primary and dominant purpose in light of the fact that it was really a residential program which offered some education. But here the issue is purely, is it educational? Because if it's educational, there's no question that this is not a high-end residential program. This is purely, I mean, so the issue here is the issue we really did not need to address in Regis, which is the program educational? There it was just not for the primary dominant purpose. But here the issue is whether this is educational.
And that's correct, Your Honor. I would agree with that, but I would also note that this court answered that question, is it educational, in the affirmative in the Fitchburg case. And
Now, I mean, I understand your position is that it can't be distinguished, and it may well not be able to be distinguished, but I think the attempt to distinguish it is to say that the education component part here is ancillary to the mental health issue, and then in Fitchburg, you have these men in this residential setting, and you're trying to teach these life skills so that they can assimilate into the community. I think that's the attempt to distinguish.
it may be, Your Honor. Frankly, I do not understand all of Appellee's argument, but I would suggest, first of all, Fitchburg involved residents who had been recently in a psychiatric hospital. They were all on medication, and they were being taught the skills of daily living. If anything, excuse me, the McLean program is far more structured and educational than what was presented in Fitchburg. In McLean, we have 4 hours of classroom every day, practice sessions in the afternoon, a very detailed curriculum, a schedule which is included, we included it in the addendum to McLean's brief, a schedule which is detailed from 8:30 in the morning until lights out in the evening every day. So I would suggest that the educational structure in the case before the court is far more prominent than it was in the Fitchburg case, where arguably someone could have said, this is really a residence. It's not really an educational purpose.
But DBT,
Go ahead.
I was going to say, but DBT, does it give you any pause that DBT stands for dialectical behavioral therapy?
No, it does not, Your Honor. Again, I think the
We're not
court,
teaching the teachers, we're teaching the skills themselves.
the skills themselves are what the dialectical behavior therapy is. It's the residents of this program and those of similar programs suffer from an acute deficit in social and emotional skills. This program, which is brilliant in its reach, is able to teach social and emotional skills to those residents to enable them to lead productive lives.
Can I ask, one, how long does the program last? Do you graduate from the program?
There is a graduation in a sense. It lasts, the McLean program that is under consideration here is between 6 and 12 weeks, depending on the student's ability and ability to learn the skills. And
One follow-up question. So has they've refashioned, they're going to get up and say, this is really basically a therapy. It's like basically group therapy. Have we had, and I understand there's a significant educational component. Have we had a case where we have to make this competing, where we have a real education program, we also have, it may very well be also a real therapy program, and we have to decide which one is primary? Is there anything like that out there? Because Regis seems much simpler in some respects.
I would suggest, first of all, that I would take issue with Your Honor's description of some other programs as real education as opposed to this program. I believe it is real education.
No, I'm saying this is real education. I agree with you that this is a real educational program, but I also find some of what he says that this is really a therapy, a group therapy approach and a clinical one, and I'm trying to understand what that primary versus, say we have two very pronounced purposes to this.
Well,
Do you win?
I don't, and the reason I disagree is
You
because
mean
I
you
don't
don't-
think you can distinguish in this case between education and therapy, because in this case, the therapy is the education. It is designed.
He's going to get up and say the education is the therapy, and I'm just trying to understand how we resolve that. Does the Dover allow two, as long as there's a very pronounced educational purpose as well as a therapeutic purpose, you win? I'm just trying to understand how this works, because
Well, again, I think the Harbor Schools case might come the closest to answering that question, and that's an appeals court decision that was decided actually 2 years before the Fitchburg case. And in that case, the appeals court essentially determined that education and rehabilitation, which was the term at issue in that case, were not terms that were so distinct that it required the court to quantify them vis-a-vis each other. They described terms like therapeutic and rehabilitative as, in that case, sort of a new lingo or new nomenclature. That was, again, back in 1978. So I don't think they're not mutually exclusive. The Harbor Schools case clearly said that. Nor do we need to separate what is educational and therapeutic when you have a very clear educational program that is the therapy.
What do you say to the sky is falling down argument that if this is within the Dover Amendment, when you have a predominantly medical regime and you have a physician on staff and you have individual therapy, that if it fits here, where won't the Dover Amendment fit?
The slippery slope argument, in other words.
Yes.
Your Honor, I would suggest that, first of all, this court, appeals court, trial courts, building inspectors, and sometimes zoning board of appeals, have had no problem distinguishing the facts before them in terms of determining what is educational and what is not educational. There are the suggestion that one personnel on the staff with medical training should be a litmus test is not consistent with this court's case law, and I would suggest that one person with medical training out of a staff of 12, when that person also is participating daily in the educational presentation, should not be determinative, nor should the fact that these residents have individual therapy twice a week, and that individual therapy is focused on how these individuals are to apply the skills that they have learned the DBT skills in their personal lives based on what they need. There are many cases, not necessarily cases from this court, but there are many trial court cases that apply that distinction, and I would call the court's attention, there are two cases, both cited in the appellee's brief and appended to that brief, and they're both land court decision. It's the Austin Riggs case, and then the second case involves an elderly housing or elderly recreation program. And the court in Austin Riggs, which was a very similar program to the one at issue here, it was a step-down program. It was conducted by a mental health hospital. The program was residential. It was out in Lenox. And the court had no problem determining that in that case, which also involved some therapy, the primary goal was to educate those individuals in interpersonal skills, among other things, similar to our case. Whereas the land court in the second case, which I'm blanking on at the moment,
That's the Judge Fenton case?
yes, it is. It's the Judge Fenton case. Had no problem determining that the primary goal in that case was recreation or adult day health care. And in that case, again, the court had no problem distinguishing, and I would suggest that, again, the slippery slope argument just is not palatable in this case and isn't a substitute. There's no litmus test. There's nothing, whether it's medical personnel, there's nothing that substitutes for this court or a trial court's careful analysis of the facts before it in making the determination of what is educational and what is not.
Can I ask you, do other states have anything comparable to the Dover Amendment?
I believe they do, Your Honor, but I am not cognizant of the particular provisions. I think there are.
The point, you can see where I'm going. I would like to know if there's any case that's like this in any other state.
Not that I'm aware of, Your Honor.
McLean's has a whole host of programs at its Belmont campus. Is it your view that what goes on, or that all the programs at the Belmont campus would fall within the education exception, or would fall within the education provision of Dover?
Many of the programs would, Your Honor. The distinction that I'd like to make, though, is that what we're talking about when we talk about Dover is the use of land. And I would suggest that appellants are not arguing, and there's no question that the primary use of the land in Belmont is for a psychiatric hospital.
So
yes, there are two 766 schools.
Help us to draw the line. If some parts of Belmont would be educational and some parts would not, tell us how you would draw the line, since you believe that Judge Shire drew it incorrectly.
Well, again, I don't think there's a line specifically to be drawn, and I think that's perhaps where Judge Shire went astray, and she perhaps also veered from the analysis by given the fact that it is McLean that is running this program. But I would suggest to you that while McLean does run several educational programs on its Belmont campus, there are two 766 schools that are unquestionably educational. We would not argue that the primary purpose of that land, that acreage in Belmont, is educational. Now, if you subdivided that land somehow, which we're not suggesting the court do, I think you might get a different result for those 766 schools. However, the parcel of land in question here, and it's the use on the land that is protected by the Dover Amendment, not the overall programs of the institution.
Let me take it one step further. Let us imagine that that there was a decision to subdivide the 766 schools and place them within the scope of the Dover Amendment. Your view is that that which remains would not be within the Dover Amendment. And tell me why.
Well,
Since it is therapeutic, what goes on.
Yes, it is, Your Honor, but I would suggest that there is a distinction between the education that McLean provides in many of its programs, and it's not just the two 766 schools, and the inpatient hospital. The inpatient hospital is undoubtedly a medical hospital. A patient's care in that hospital is directed by a doctor. They are they see psychiatrists on a regular basis. They are given medication. They are given treatments that are treatments, tests, EKGs, other types of tests that are indisputably medical. In this case, the land court very specifically found that there were no medical treatments involved in the McLean program. So I think there's an inpatient piece to the McLean Hospital that is very clearly a hospital. With that.
Thank you.
Thank you very much, Your Honor.
Mr. Tallerman, good morning.
Thank you, Your Honor. May it please the court, my name is Jason Tallerman. I'm counsel to the town of Lincoln. With me is attorney Michael Fee, who represented our co-defendants, who are members of the public who initiated the underlying zoning action. I'd like to start maybe with this slippery slope argument and then back into some of the other arguments I want to make. The record is clear on what is being argued in the facts of the case. Ms. Tillotson and her client argue that DBT, in and of itself, the therapy that is DBT, is inherently educational. The materials they themselves provide, and they start on page around 1181 in the record, indicate that DBT is administered across the spectrum, from outpatient to partial hospitalization to intensive residential facilities.
But not here.
No, here, too, in residential facilities.
No hospitalization here.
There's no hospitalization, but it's taught in addition to the residential. Their own materials talk about a partial hospitalization usage of DBT.
I don't understand that. Where is that in the record?
Around page 1187, I believe. DBT is taught originally in a purely outpatient basis, and the evidence indicates that residential DBT programs are more of a newer construct of the DBT regime. Regardless, the testimony and the evidence indicate that the same basic principles for administering DBT are the same across outpatient. Both parties' witnesses agreed to that. The same book by Marcia Linehan provides the same mechanisms, the same basic structure for the treatment of this illness. It's a serious illness. It's a serious treatment. This is cutting-edge, state-of-the-art, the most proven and most effective treatment of borderline personality.
So are you saying that if they did this in a hospital, they would do it the same way with 4-hour classes and homeworks and admission standards and not being, I'm getting confused.
So what I'm saying is what they say is primarily educational, and they use words like classroom and schedule and teaching. The skills session that they teach, the curriculum, and it's the big exhibit number 2 before the trial, the daily exercises, the daily things that they do are the same across the board. That is what McLean suggests are primarily educational about this and what makes this not therapy, not treatment, but educational. That same construct, those same skills, that same approach to helping patients who are self-harming themselves or who have ideation of self-harm is the same.
Well, you used the present tense. If somebody's suicidal, I don't think, based on the record, they could actually even be admitted to the program. And help me with Judge Shire's factual finding that didn't she find that there was no medical intervention here?
No physically medical intervention, but there's indisputably a doctor-patient relationship here, indisputably admitted by McLean. There's a doctor-patient formation here. That relationship is formed here.
I mean, one doctor in the patient population, right? One doctor.
Not necessarily just one
psychiatrist.
doctor. The doctor, though, is at the top of the heap. That is an admitted thing. The buck stops with the doctors here. They administer the program, they coordinate the program, they coordinate the team. In Fitchburg, it was stated that when you cross over, when you form that medical relationship, when you're treating people who have a history of self-harm or suicidal ideation, you have crossed over. That's not dicta in Fitchburg. That's in the case. It's not an afterthought. Fitchburg made that dividing line. Austin Riggs, a case that was just cited, found primarily that it was Dover protected because there was no formation of that medical relationship. Same with the life studies case, the Fenton case. The judge used that language as a backstop.
So the program can't be both therapeutic and educational?
Yeah, I think it can be both. The question is what is the primary purpose? That's what we learned from not just Regis. The primary and accessory purpose exists in other Dover cases.
And the judge here found it was primarily therapeutic.
Correct.
And what is our standard of review looking just at that finding?
Your
For us.
standard of review is you have to make that finding. This is not altogether different than the Regis case.
So is it our own finding, or do we defer here?
Well, I think you have to defer to it's an interesting mixed question of fact and law. I think my understanding, and having done a lot of zoning cases as a municipal practitioner, is the question of primary and accessory is a legal question. The facts underlying the basis for your decision in that regard is a question where you would defer to the fact finding of the judge below.
Where does she find it's primarily therapeutic?
It says I believe in the very last sentence, or very last
Fact
paragraph,
finding?
Your Honor.
Is that a fact finding, or is that a ruling?
I would suggest, in fairness, that the conclusion that based upon the facts that something is primarily therapeutic as opposed to, I think let's back into it. If they're finding that the primary purpose is not education, that is a legal conclusion, in fairness, but I think the facts underlying that decision by the judge are entitled to deference.
And she mentions it on page 2 as well. For the reasons set forth below, the court determines that the use of the property is primarily therapeutic.
Correct.
So it's a determination.
Correct. And then she finishes with this, with the same principle. Now, look, McLean is a cherished institution. Lincoln already plays host to a Dover protected facility that is operated by McLean. We have no quarrel with that. I have done other Dover cases in Lincoln as well. The zoning board is not a star chamber. They have reviewed the facts and determined on the basis that pretty much the same basis that the land court judge found, that this is primarily therapeutic. Let me draw a dividing line, if I could, between the therapeutic aspect of this and the treatment aspect. We can get back to the slippery slope argument too, because I think it's important, and some of the other more life skills cases, because it comes up pretty frequently. The cases as we know them, there is no case anywhere that has said a primary purpose of having psychotherapy as the primary purpose is Dover protected. That case doesn't exist.
This isn't primarily psychotherapy. This is not them sitting down with a psychiatrist all day long. Most of the people teaching are not medically trained, right? They're
are
teachers of some sort.
I take slight issue with that. I know it's a nuanced argument, Your Honor,
No,
but
that's what your job is. Go ahead.
but my view of that, and I think the view of the facts on this, is that the doctor's at the top of the heap. All the witnesses by McLean were the doctors who administered and designed this program. This program doesn't run if the chief isn't a doctor administering a very complicated, very complex, very highly coordinated team of people, and I think the term used in the trial court was all rowing in the same direction. And it's the direction supplied by the psychiatrist at the top of the program, the same psychiatrist who testified before the court. Now, the life skills cases,
But
Okay.
Again, the one I'm most familiar with is mindfulness. Now, mindfulness is being taught in half the high schools around the country. It's not a medical intervention, right? mindfulness is some kind of, there's an educational component that's different from treating a disease. I'm confused by what I understand that they're creating an education program designed to address a skill set for boys with a particular set of mental health issues. Not even identified diagnosis, right?
Right.
Some of these kids.
Well, no,
Some might.
Every or not always borderline personality disorder. In fact, the testimony is that the majority of them carry that, but they carry other diagnoses as well.
But they don't, from what I understand, to get admitted into the school, you need to meet a particular, it's not a clinical definition, but you're sort of in between definitions in certain ways.
I don't believe
Okay,
that the
all right.
evidence supports that. But getting to the mindfulness question, I want to circle back to the life skills question. You know, there was an interesting dialogue on the witness stand between myself and one of the witnesses supplied by McLean. There's some of the exercises that they do, cooling down. This is a patient population, and they are patients because it is a doctor-patient relationship. This is a patient population that does not have the ability, because of their illness, to cool down. They teach them things like the importance of exercise. The example that I gave is that if I've had a particularly tough day at work, I blow off some steam by going for a bike ride. I feel better, I can focus a little bit more. That's part of their so-called curriculum. If that curriculum, if that type of exercise, and those kinds of exercises are across the spectrum here, qualify as educational, then again, the example I give is the orthopedist office.
But aren't they equating to a school? Like a high school will have a sports program or have gym. They will have mindfulness. I mean, they're creating a set of education programs directed at these type of deficiencies or skill sets these kids need. I just don't understand why that
Their
wouldn't-
deficiency is as a result of a mental illness.
I get that.
But the
That
life
is the key
skills.
distinction here.
But the life skills they're being taught aren't necessarily therapeutic. It's for them to be able to have the education to manage and address the issue.
So I disagree with that. So this is a proven technique since Marsha Linehan developed it, and she's the kind of guru behind all this. Her book, which is in evidence, is not to educate. Her book, her exercises, and the McLean doctors here are disciples, so to speak, as was the doctor that we provided, is to cure a significant or manage a significant mental illness. If you go to a facility that provides life skills, some of the ones that were decided have already been decided by this court and the appeals court, and you learn things like budgeting or job search training or cooking or hygiene or parenting, you're going to those facilities literally for those reasons. That is the prime motivation to go to those facilities.
Well, suppose you want to go to a military school. You want to send your kid to a military school because he's nothing but a problem. Is a military school less a school? Because they're going to deal with behavioral issues?
But it's not treatment.
Well, how do you know that?
They might have an ancillary treatment, but they are still, as in the case with a 766 school, which has treatment in it, they are still a 766 school that has a primary academic objective. That is in the evidence as well.
I'm going to read you a line from Fitchburg. Inculcating a basic understanding of how to cope with everyday problems and to maintain oneself in society is incontestably an educational purpose. Do you agree with that?
I agree with the line of cases, sometimes
Do
as a
you agree with
municipal
that
practitioner.
Do you agree with that principle?
I agree with that principle, but in the abstract more than when you consider all the facts.
Let's consider it in this context.
Sure.
If you have a child who is unable to concentrate and focus for more than a few seconds and therefore cannot think about hard things, and if you have a child who is easily derailed by things that would not derail most of us, and if you have a child who reacts in social situations in a manner that makes that person incapable of dealing with everyday social situations, why is that not as much a life skill and the ability to cope with everyday problems and to maintain oneself in society as, why does that not fit within that rubric?
Well, I think let's look more holistically at what Fitchburg said in terms of how it, bless you, how it reached the conclusions it reached. In Fitchburg, some of the life skills which ultimately turned the court towards the educational, learning to shop, how to use money, learning to
I
cook.
understand what Fitchburg addressed, and my question is, here, what is disabling and what this program seeks to enable is the ability to focus and pay attention and concentrate and address problems, the ability to interact successfully with other people, all of which may be necessary for that child to be able to be educated and to be able to interact successfully in society, which is a necessary element of everything that's going to happen to that child in the future. So why is that not educational?
Well, again, I would say two things, again, turning to what has traditionally been the case, and there is no case on record, again, that talks about a mental health treatment converting itself into education just because of the use of classrooms or structure, is that, again, in Fitchburg, the line that they didn't want to cross, despite that educational goal, was when there was a doctor-patient relationship involved and when you're dealing with a population where the primary goal itself is to stop self-harm behaviors. Unquestionably here, the primary goal, this is beyond dispute, all parties agree, is to stop self-harm behavior.
It's more,
before you
isn't
get
it more
into
than that? Isn't it to enable
the
the
primary
student to
goal.
be able to do things that are necessary for everything that would permit success in society, to be able to concentrate and focus and think without losing, without getting scattered, the ability to interact with, aren't those essential skills?
Right, I would say two things about that. First of all, that is the same exact goal for every mental health treatment in every McLean program, admittedly by their own witnesses. That is the goal of mental health treatment everywhere. So we're back to the slippery slope argument. Secondarily, I would say that the primary goal, again, not my words, the program's primary goal. Number one, they have like 4 stages of goal. The first goal is to stop the self-harm behavior. That's number one. Number 2 is to stop the interference with the therapist relationship with the patient. Before they get to that, they're working on the treatment of the illness to stop the most dire consequences of the illness. Look, if you're a parent and you're about to spend $1,400 a day, $38,000 for a 28-day stay, you don't care about a classroom structure. You care about getting your kids some treatment. If you're, on the other hand,
But is that, don't you have a choice? You could also spend $38,000 to put them in a hospital somewhere to get individualized attention, right? You're making a choice between the hospital setting and this program, right?
that's so, two things
But
about that.
So does that matter that
It
you're
does
doing it
matter.
in an educational context?
First of all, if you did that and it failed, that's why you're here. Most of these kids failed in a hospital setting, and that's why they're here. Second, that's a philosophical argument.
That cut against you?
No, because I think Regis says this is about land use, not philosophy, not how you may choose to get there or what have you. This is what is the land used for? And if you are the person putting your kid in here, you're using this land to get your kid treatment. If
Why
you are
isn't
the
why isn't the parent saying, gee, you know, this hasn't worked when we've tried these other places. Let's go to the place that's going to educate my child about the skills that he or she needs to be able to manage with the mental health issues in the real world? Why is that not education?
I think when you apply the reasonableness test that's at the heart of Regis, which is let's not elevate form over substance. Let's not get philosophical. This is about land use. Let's not engraft an educational component
But
on
isn't there a
another
form
use.
over substance that you're arguing when you're saying, well, there's the doctor present, and there's not the doctor present in Fitchburg? I mean, that's a little
No, but
form
those
over
are
substance.
indicia, I think, of what is really going on here. What is really going on here? If I'm that desperate parent and my kid has tried to hurt himself, I'll do anything.
But
I'll
don't you-
mortgage the house.
But isn't it important to the parent also that the child, I'm sending the child to school, I'm not hospitalizing.
There's no school here.
Well, but I'm sending them to the 3E program, which is, I'm not hospitalizing my child, I'm sending him or her to, in this case, him, to a program that's educating. There's some comfort to the parent in that, isn't there?
I think the comfort to the parent is in the efficacy of this program and how great it is. Look, Dr. Lewandowski testified that this is so structured and so intense, and they keep these kids so busy from the moment they wake up, going through this treatment, that they simply don't even have time for vocational or academic training. There are no indicia of cooking, of budgeting. If we go down this road, again, we're back to the slippery slope argument, then literally anything that we do, regardless in the mental health arena, the goal is the same across the spectrum of mental health treatment at McLean. Get kids and adults back so that they can lead a healthy life. That is the goal. That's their stated goal for the entire facility. If that's it, then I, as a municipal council representing my client towns, are gonna have to say, anytime someone opens a doctor's office that wants to administer DBT, Dover protected. You wanna administer regular therapy with the goal of getting someone back on their feet with a less rigorous, where are we gonna draw the line? It's a really difficult line to draw. I don't envy the decision
Do
you
you
have to make.
agree, do you, that's why we get paid the big bucks. Do you agree, do you agree that if you're teaching life skills, that's an educational program?
I think if that's the primary use of the particular property, then yes.
And if you're teaching occupational health life skills, as in Fitchburg, that is an education program.
I think as long as it has all the indicia that Fitchburg had, in addition to the purposes that you and I were talking about, again, they taught some very pure life skills things that were determinative to that court.
But if you're teaching mental health life skills, you say you've crossed the line.
Because I don't think that's teaching mental health skills. Here, I think the key fact is they're treating kids through the use of some devices that have proven to be therapeutic in nature.
What if we had a student who had a physical disability and we were teaching the student other ways to compensate for their physical disability? Would that be educational or therapeutic?
I think it depends in the context and who's administering that. Again, if you were in an educational forum, so we had sub-witnesses in this case where DBT is being used in an ancillary capacity at a purely educational facility, fine. It's not altering the primary purpose of it. There are guidance counselors, occupational therapists, and many other different types of professionals who have a crossover at schools, in many of the types of schools that we discussed in the case themselves. All of that is going on is an ancillary and vital component to a facility that uses the land it's on for an otherwise educational purpose. I have no quarrel with that. That is not the argument that we have at present. What we have at present is a facility that first and foremost is treating really vulnerable kids to help them get a grip on a mental illness.
Well, what if you have a young kid who's got type 1 diabetes, and there's really serious implications if it's not managed well, very serious implications, and you go to a program that teaches that child certain skills that he or she may need to manage manage the type 1 diabetes? Is that therapeutic or educational?
If you decide this in favor of the appellant, it'll be educational. Right now, I would call that treatment. And that was exactly the example that I asked Dr. Lewandowski about on the stand, diabetes. Look, I'm of that certain age where I just had to go get a colonoscopy. I left with a book of how I could be healthier. I had a 10-minute discussion with my doctor afterwards of the things I've done wrong and the things I can do right to be healthier and happier.
But you didn't
Diet and everything.
But you didn't get your colonoscopy with 12 other people in the room.
There was actually like 20 other people around.
And then have discussions about how you felt about your colonoscopy. You know, it is a little difference, isn't there?
There is a little bit of a difference, but if you are in a juvenile diabetes and you have to teach a kid a life or death, then this is life or death for these kids that are suffering from BPD. You have to teach them a life or death series of exercises that they have to complete every day. They've got to monitor their blood sugar. They have to know what to look for. They have to know the warning signs. And it's not just you, it's your parents too. That's part of the treatment. If we decide this the other way, and this is all to help them live a happy life, and again, that's their goal. That's a quote. The goal of DBT, by their own witnesses, is to get kids out of the system and so that they can live a happy life back at school or back with family. If you're treating a kid for diabetes, that is the goal. You want them to be able to assimilate easily without having to be miserable and unhealthy all the time. If you twist your back playing basketball and you go to the orthopedist and you are miserable all day sitting because you just haven't managed it, and they teach you a number of different ways to stretch properly, to eat properly, to not overdo it. You're being taught something. After this case, if this goes in favor of the appellants and you reverse the land court, where is that dividing line? You're being treated for an orthopedic injury. You're being treated for diabetes. You're being treated for some kind of other mental illness.
So it depends on the population, in other words.
Well, I think everything's contextual, don't get me
Because I
wrong.
was going to ask you about, suppose you had a school or a facility for children with autism or on the spectrum, and who could not function in an otherwise regular school. What is that? Is that an educational purpose?
So you're talking about, and I think this is an important distinction, Your Honor, if their baseline is autism and they're not really getting treated, it's a.
Well, they want to be taught. They have to be taught skills.
That's the difference.
Skills.
Here you're being treated for something
But
that is
they're
an
being taught
illness.
skills.
You're not curing autism, though.
Well, I'm not sure you're going to cure borderline personality disorder. You're going to manage it.
It's to effectively therapeutically treat. In autism school, you're not using therapy to address their autism. You're teaching something so that they could assimilate better in school or in society, the job training aspects. That's the life skills cases. That's what they're doing there, in addition to likely academic components. Those are the 766 schools and the schools that have a pure academic component. That's Harbor. That's the Harbor School case. There was an academic component in addition to the top of the recognition that these people have some type of mental disability. The question is are you going to engraft, per Regis, a small educational component onto an otherwise larger use to gain the protections of the incredibly beneficial protections of the Dover Amendment? And we think the land court got it just right here.
All right, thank you.
Hey, thank you very much.
We'll take our morning break.